As a law lecturer, this is what I need you to know about pure economic loss in roughly about 60 seconds. Make sure you save this video. When it comes to economic loss, then this is basically the financial loss that you suffer from some sort of physical damage that's happened. Now, there's two types that you need to know about for exam purposes. There's pure economic loss and then there's consequential economic loss. With consequential economic loss, this is the financial loss that you will suffer that comes directly from the damage to the property. So, for example, if a car crashed into my shop window, the fact that I'm going to have to close my shop and lose out on profit for a week, that is going to be consequential economic loss because it's come directly from the damage that occurred. Pure economic loss then would be not coming from the damage whatsoever, and usually it's not something that I can claim for. For example, say the car now crashed into the electricity pole outside my shop and that meant that I couldn't open my shop and I lost profit for a week, then that would be pure economic loss because really the loss hasn't come from the damage itself because my shop is absolutely fine. Now, when it comes to pure economic loss, there is an exception as to when you can essentially claim for pure economic loss, and that's when there's been a negligent misstatement. In a nutshell, a negligent misstatement is when there is a non-deliberate, non-malice statement being made that you've relied on and that's cost you some sort of a financial loss. So for example, if I take advice from somebody on buying a house and I end up losing money on that house, that is what we're looking at under negligent misstatement. The case of Spartan and Steel is a really good one that talks about how you cannot claim for pure economic loss, but the absolute key case for negligent misstatement is a case called Hedley, Byrne and Heller, which, as I've already mentioned, says you can claim for pure economic loss as long as there's been that negligent misstatement. There is usually a 4 to 5 part criteria, depending on what spec you're following, that you have to be able to fulfill before you can make a claim. But when you're using this 4-part criteria in any problem question, you must be linking case law as you do it. Now, let's have a look at a very quick scenario together to see how you would apply this in any kind of exam situation. Let's start off with the first part of the criteria. Was there a special relationship between the two people involved? Well, yes, she is talking to her accountant and obviously she is going to be a client of her accountant. Next, has there been assumption of responsibility? Well, yes, if a client comes to an accountant and they give them advice, they know essentially that person is going to be using them advice, so there is that assumption of responsibility there. Thirdly, would it be reasonable to rely on that advice? Well, yes, again, she trusted him, that's why she's gone to her accountant. A client often trusts their accountant, so yes, there absolutely is going to be an accountability of that advice. Finally, has there been a financial loss? Well, yes, of course, she's lost over £3,000 from the advice that was given. So according to the case of Hedley, Byrne and Heller, yes, there would be a claim made for pure economic loss because of a negligent misstatement.